Well, hello. My name is Chip Merlin. I'm glad you're here for Tuesdays at 2 with Chip, and I got Larry Bache here again with me. We'll be talking a lot today about the physical damage, and Larry, I think this is the sixth time, maybe the seventh time we've done this presentation, together.
Yeah, we had to narrow down the PowerPoints how many times we've actually done this.
For everybody who's joining us and they're talking about the coronavirus and your business is shut down, we're sorry about, everything you're going through. And we have a lot of people asking questions. I'm going to address that. It's one of the first things I'm going to be addressing today. But the topic of physical damage is very much a part of that. And, but it's not new to us. It's been going on for a long time. When I was going through some of the paperwork that we've written in the past, and even over a decade, I've been writing about this. And we'll talk about where you can go for if you're an adjuster, a public adjuster, if you're an attorney watching, if you're a business owner who's watching. We have a lot of information about this. That handout that Megan, I guess everybody can get to that handout. It's usually one of the first things. We only make these handouts available for the people that actually come in and watch us live on it, just because it's your gift that you might get for actually showing up live to go ahead and watch us as we go through it. But I went through and picked out a number of different blogs that we've written in the past, academic papers about. We even have a brief that won in front of a federal appellate court to help people in their battle, especially right now with respect to the coronavirus. But I say battle going on. The truth of the matter, if you're a contractor, a public adjuster, and you're out in the Midwest, and with all the hail damage, tornadoes that have gone through, a lot of times there's a lot of cases where you have this concept of functional and cosmetic damage, where the insurance companies are saying we don't pay for any cosmetic damage, we only pay for functional damage. And so I'll be talking about that as well, and these new terms that insurance companies are coming up with. If you get one of our blogs last week, I really fell out of my chair when I was working from home, and I had a television screen up to the right of me, and all of a sudden there's the president of the United States start talking about business interruption coverage. You just got to go, what? And out of the blue, Donald Trump starts talking about business interruption coverage. And he starts saying he had businesses, he has hotels that were shut down from hurricanes, and his businesses was interrupted. And these insurance companies ought to be paying these small businesses that have been out of, they've been shut down. Their business has been interrupted. They've been paying premiums for 25 and 30 years. And it's just not fair that insurance companies aren't paying them. And the insurance executives know it's not fair. It's just about what Donald Trump said. And then Mr. Trump also said that, President Trump said that he knows how to read insurance contracts, and he couldn't find the word pandemic anywhere, in the insurance policy. And I felt Donald Trump sounds like some of my clients that are calling me up, just about, because he has that same type of view that everybody else did. So this is a topic of physical damage that we've got, but also has a lot to do with the coronavirus. And I guess, Megan, we can keep moving. I don't know, where are we on this PowerPoint?
Yeah,
I can't see it.
Before we get started, thank you all for jumping on, and hello to everybody that's saying hello back. We are hopefully trying to be educational, but also a little bit entertaining. And we hope that you guys participate in asking us questions. We do have Megan here to help us. And Chip, you've got the screen today. So if you see a question that pops up, just interrupt me and ask the question. Chip and I will address those. We do have good content. And the benefit that Chip was talking about in opening up the PowerPoint, which there should be a link that you can access in our comment section. So please take a moment to open the link. And within that link, you're going to find hyperlinks, just like we had last week. And you can download those materials. So it's very beneficial. Now we're in trouble because Chip has the mouse, and we'll answer a lot of questions that you guys have.
We have the mouse, but later on we have a cat in this show too, which is kind of fun. So where are we?
Sorry. So we're going to be, y'all know who we are. So we're going to get past the biography.
There I am.
Yes.
If you think about, the two of us right here, I started thinking about Larry and stuff, and that's Obi-Wan Kenobi. So if you ever want a wise sage that can help you out, and you want to have the insurance companies come show up and you say, hey, don't think about it this way. Make sure you think about it that way. And the insurance company adjusters will go, we need to think about it that way.
Right.
You'll come see me. Now, if you want, what Larry is, though, because we go to the other thing, there's Larry. Larry is definitely Yoda. If you look at him, he's definitely on the way to becoming Yoda. if you know him at all. And his brother Bobby is probably sitting there laughing, saying, yeah, Larry is on the way. And see, like in Moneyball, see old Mr. Brad Pitt, there I am. And there's Larry next to me again. And there we are. Larry is in that book, Pay Up, right here. He's on page 89. He wants everybody to know that. He got his name in a book. And
so now we're going to get past that.
We're going to get past all that kind of stuff. But now you know who we are and where we're from and what we do. And for what it's worth, we've been doing this a long time. I get asked this question all the time from insurance agents. I had an insurance company lobbyist call me today. I had a reporter call and then put me on, and it says, Chip, for all the people that are out there, all the businessmen that are shut down, everybody who might have a certain amount of damage, what are they to do? And it's notice of loss provision. And the notice of loss provision essentially says, because it's almost in every single insurance policy, that you have to immediately, as soon as reasonably practical, notify the insurance company of a loss. It's a requirement under the insurance policy. And if you fail to do so, this is the rule here. The failure to notify an insurance company within a reasonable time might constitute a defense under the policy. So anybody who does property insurance law for a living, and any attorney and almost any agent, as a matter of fact, there's some discussions from insurance agents that'll say, hey man, I got a deductible, it's $50,000 and I think my damage is only 30. Should I report this to the insurance company? And a good insurance agent will tell its policyholder what?
Yes.
Report the loss. Why?
Because they have an obligation to do so.
And what might happen later on if you find out it's above the deductible and you fail to notify them of the loss?
Then they'll deny it because they've been prejudiced.
So if we go to the next slide.
Right. So now we're going for the notice of loss slide. And another we could probably do,
but you're not done,
is going to be,
but report the loss. So my main thing is report the loss. And people are asking me, well, Chip, why should I report the loss, on the coronavirus cases right now? Why should we be, calling the agents, if there's really not a chance to win? Is there really not a chance to win? There's lawsuits that are being filed all over the United States. A lot of them are challenging the virus exclusion. A lot of policies don't have the virus exclusions in them. I don't know exactly how those cases are going to come out for sure. You don't. I can't predict the future. If you can predict the future, we probably wouldn't be lawyers right here talking with one another. Would be doing something else. Now, if I put my wizard hat on and I can predict the future, but that really wouldn't be fair. Now, would it, Larry? No. So I'm not going to predict the future and tell you what's going to happen, but I am telling you, report the loss. There's a whole nother reason why for it. There are 6 different states that have already filed legislation that would tend to indicate that, and if this legislation passes, businesses with 100 employees and less are going to be able to make a claim for business interruption because they're going to retroactively change these policies. Now, I know a lot of people in the insurance industry are probably rolling out of their chairs with the thought of all this happening. And then the next thing I know, I read letters from Marsh Mack and some other leading insurance companies that are writing the president of the United States about, hey, why don't we have something like a PREA, similar to the terrorism risk insurance? We're going to have something for pandemic. And there has been some discussion in Congress, and I've read a draft bill that we disseminated throughout that talks about the possibility of having a retroactive backstop in these particular circumstances with respect to providing business interruption or business income coverage. So I'm the attorney. People are asking me, what should we do? You have one obligation. There's no downside to go do this. Report your loss. Call your insurance agent, put it in writing, ask your insurance agents to put it in writing to the insurance company. Just make certain you report the loss. That is your main obligation right now that you have to do if you ever intend to make a claim under this policy. There's a couple states that might say, oh, if you fail to report the loss right away, it's not necessarily going to prevent you from recovering, but almost those states also say so long as there's not prejudice to the insurance company. So do yourself a favor and everybody else, report your loss to your insurance agent. I would also suggest that you get counsel on this. Every single policy is a little bit different. And I always say RTFP, which means read the
flipping policy.
Full policy. So you need to read that full RTFP. That F, as I say, sometimes stands for something else when people keep calling me up and asking, hey, does my policy cover this? Yes or no? And you got to read the policy, man. They're all a little bit different. There's a few policies out there that we've read absolutely provide coverage. I don't know if people saw this or not. Wimbledon's going to collect, what's it, $142 million. They paid $2 million for the premium, but apparently collect $142 million for canceling the Open Championship over in Wimbledon. It's a lot of money.
So we're going to go to the next slide.
We're going to go to the next slide. And we're talking about, and this is something that's come up with insurance companies, a lot of insurance company engineers and things like that. And they'll say, well, there's cosmetic damage that's going on here, but it's not really damage because there's no functional damage to it. And I wrote a blog and I got kind of upset, and I said, you know what a great example of this is, and let's go to this next one. See, there's an American flag. That is a beautiful American flag. Don't you look at it, just waving in the air, the red, white, and blue and stuff like that with the blue background. It's both no cosmetic damage, no functional damage. And then next thing you know, it's all tattered to hell. It looks like it's been at Fort what? Where's that fort in Maryland? Now I know somebody from Fort I forget, anyway, but that's a different flag. It's been ruined. It's obviously cosmetically damaged. The insurance company says there's no physical damage to this because it still functions as an American flag. Everybody can see it's an American flag. You can make it out, but no damage to it because it's the same way. And so then we get down to some more practical things as we go through, and then they start saying if there's damage like this on the side of a roof or on a roof or on the side of a wall of a building, is this cosmetic? There's no functional damage to it. It's still acting as the side of the wall. Hey, just because it's got some dings and it doesn't look, very good, that doesn't constitute, damage. We're going to talk about that this afternoon in our, presentation to you, and also show you what the insurance companies are coming back in response to this into the changing policy language that's coming out, which then gets back to even when today you're not talking about the coronavirus claim, you're talking about roofers and contractors and whether or not your building sustained damage from the tornadoes that just went through, but hail, balls went all over the place. Hey, I got through the tornado, but look at the side of my walls. Is this damage or not? And then we also have the next slide. So we're into that commercial property. We have all these other articles that I have in there. I have a number of academic articles, not just from our side, but Shannon O'Malley. I've known Shannon for a long time. She's a great attorney. She's an insurance company attorney. I wrote a blog recently that she actually wrote back to me. She says, Chip, I'm not famous, I'm infamous. I said, you're a celebrity. You're the queen of no. I mean, no, we're not going to pay you anything. But she does lay out, I think, a lot of the issues for the coronavirus insurance coverage, back and forth. So people can at least see the issues. And certainly she represents insurance companies. That's what her firm does with Steve Badger and other very good attorneys over at Zell. But if you don't know what they're going to argue, you don't know how to respond back to it. So
we got a bunch of blogs on the top.
We have a bunch of blogs. If you want to go, all you got to do is Google, put Chip Merlin blog, Chip Merlin property blog. You put Chip Merlin pay up, that'll take you to a different blog. But if you go Chip Merlin blog, it'll take you to property insurance coverage, and you can subscribe to it almost every single day or every other day. We've been posting upon in the afternoons, usually on the coronavirus issue. We also have everything else there. If you put the word physical damage, in quotes, you're going to get 30-something different articles we've written for over a decade now about what constitutes physical damage. So it's not just something that's brand new. This topic of what constitutes physical damage has been going on for a long time. Go back. And so we talk about, like Neil Hall in his academic paper, you're going to talk about this, cosmetic versus functional damage. And we even talk about where the term functional damage came from. Everybody from Hague Engineering right now is going, you're really going to tell everybody about how we made this thing up? Yes, we are. We'll talk about it some this afternoon. We talk about, is a dented roof, cover direct physical damage and loss? Of course a dented roof is. No, but hear me out. This is where it gets, is a dent to a, let's make it up because I had this happen to me, a bleacher seat, a aluminum bleacher seat out in the field somewhere where next to a baseball field by a high school. And I said, see all this damage out here, Chip? And I go, yeah. And it's got these little pits down there. Is this damage or not? And I'm looking at it, but it's a good question because it's physically changed. Of course, the answer is yes, it is. But let's keep going. We got these articles that we have in here from the American Bar Association. It would be written back in 2009. And actually was talking about, and if there was one thing I think is true with respect to most, and I would say probably 80% of the physical damage cases, and what's the trend of those? And I think we'll get a sense of that, especially if you read this article that we have as part of it. This is American Bar Association section of litigation. They had a conference on physical damage. pretty nerdy, isn't it? Can you imagine a bunch of people just sitting around talking about cases? Is this physical damage or not?
Well, that's what we're about to do. So
And that's what we're about to do. But it's pretty
very
nerdy.
excited about it.
That's why you look like Yoda and stuff
Yes.
like that. But, you know, hey, I have a little more fun with it. See, you just want to move on from that.
Yeah.
But if you go back to and you actually read, Larry, have you read this?
That's when you say that. Because
He's got it right here. See, there he is. He's even got highlighted even.
yeah,
So he remembers it. But, you know, cases that talk about, and that's a great case to talk about where you've got, you know, electricity that's gone. It might damage your property because the computer is useless. The trend is things that take away the loss of use. And even if you can't see it, you know, where you might have obnoxious odors, contaminants, maybe even a virus that people would think is just going to go ahead and kill you and things like that would constitute physical damage. And I'll suggest to you, if you're reading this, because some of the articles I have, and they're like, why does Chip have this in here? Is I read some of the cases as we go through. Some of the judges even go through and say, geez, you know, what's physical damage in the criminal world? What do you mean, Chip? Well, no, if you read up what's physical, what would constitute physical damage? And they even talk in some of the cyber cases. These are like the hacking cases and stuff like that. Well, you know, you can't see it, but you know it's not there. You can't use things anymore. It's against the law. It's a crime. And they define it as property damage. Property damage, because they call it the loss of use, because of somebody what physically is doing, especially at the microscopic level, is that. And you have to counterpose that, because that's probably 80% of the cases. And I would suggest 20% you'd have to be really, really, if you just go ahead and take dust and you dust it off, because you can't call just regular old dust, you know, physical damage. You know, which I would suggest maybe you could, but it's a lot less than almost anybody got for deductible. If you want to make an insurance policy to cover me every time I have to have dust, but I don't think it's almost disingenuous. But I hear insurance company people do it. Do insurance company attorneys ever disingenuously argue anything, Larry? All the time, because they got to. Their clients are telling them, go win the case somehow, guys. So they got to make this argument that somehow if I come walking and I'm slobbering all over Larry, you aren't 6 feet away from me, bud, you know, but you don't know. So if I started coughing and wheezing and all this other kind of stuff, and I've got it all over, and I start screaming and hollering, I got the coronas, man. And I got it all over the place. You would jump up, walk the heck out of here, and you'd be afraid to touch anything in here. Do you think you'd clean it up? Do you think you'd just go with your hand and just take it like that? No way. It's not like dust. It's dangerous. As a matter of fact, I started pointing some stuff out to other people today. There's even all these OSHA standards that are out there. OSHA's come out. This is what you need to do to sanitize everything. And they're talking about the property. They're not talking about sanitizing a person. They're talking about the property. And it's because the coronavirus can get on property and it can be in the air. Oh, we don't pay for the air that's on the inside of your building. Really, we're going to disprove that on some of the 80% of the cases that we're going to talk about today, including the one you'll always remember, the cat. Just remember the cat's coming up. We got another 40 minutes of this fun-filled stuff this afternoon, Larry. Now,
all right, so now
let's Yoda along.
So let's go to the next slide where we talk about the ISO language. We felt this topic was really pertinent right now because the coronavirus issue is leading to a lot of articles discussing what is direct physical loss or damage. But if you're doing hurricane claims or you're doing hailstorm claims, you're very familiar with this argument. The carriers come out and they hire these engineers, and we're going to talk about where this definition came from Hague Engineering. I have deposed Scott Morrison, and I found out, and I'll disclose that to you guys. But more importantly, we see this all the time where the carrier comes out and says, this is cosmetic damage to the roofing system, and it's not covered under the policy. And they used to say that it did not qualify as a physical loss or physical damage because it was still functioning as its intended purpose. Now it's evolved because we know that's not true, which we'll get into, and now they have cosmetic damage limitations. I do want to preface this provision. This is the ISO.
Well, some insurance policies have those limitations, not all of them.
No, most don't.
And especially if they don't, and one of the things I gave you, Ed Eschew's one of the smartest attorneys, the Merlin Law Group attorney up in Chicago, wrote a whole article about these. And so if you're an insurance company adjuster and stuff like that, and you have these engineers out there writing, oh, it doesn't, there's no functional damage, therefore there's no physical damage. Ed's written a whole thing about how that is really an unfair claim practice act, as some people would say bad faith, and how you might be able to sue on it And we've got that included in some of the handout materials too. Again, you can call Eddie's up in our Chicago office. Go ahead, Larry.
Yeah. So this provision is ISO. There are different provisions. For example, there's policies that only insure for financial loss, right? And that's different than this provision. And there's not a whole lot of case law on other provisions, but this is the most common, and therefore it's the most used. And there's more case law on this issue than anything else. But the direct physical loss or damage to property is the trigger. So what does that mean? And this is where we get into the slide of cosmetic versus functional damage. Larry, I've got tile, metal roofs is the best example. Okay, I've got a tile or a metal roofing system that 1.5 inch hail and came and caused dents, actual physical dents into the property. And the insurance company comes out with their adjuster and they immediately hire a engineer. And as a public adjuster or contractor, you know what's coming next, right? You know the engineer is going to say that there is no functional damage to the property. And where there's a disconnect is that if you read the conclusions from Hague Engineering and EFI Global and Donut, you'll see that in their conclusions, they will say there's no damage as a result of hail. But when you actually read the full report, it's about how they define damage. And how they define damage is inconsistent with how the case law and how the insurance industry defines damage. And that's very important because that leads to a lot of wrongful denials and delays of claims. In fact, in Colorado, after the May 2017 hailstorm, I would say 80% of my cases that were for bad faith involved an insurance carrier who hired an engineer who wrongfully defined damage that's covered under the policy. So it's very important. I will give one carrier credit. I met with their attorney. I met with their in-house counsel. We went over this process with them, and they actually didn't realize that the engineer was applying a different damage standard than what was actually covered. And so the carrier actually met with the engineer.
Do you want to tell everybody who the carrier is?
It was actually American Family in Colorado.
I dumped on American Family last week, but hey, you got to give kudos where they deserve. So American Family, you explained that to them.
Yep.
That's good.
Yep. So the first article that I want to direct your guys' attention to in the next slide, and you can access this online. This is a blog from Hague Engineering, who is really kind of the developer of this definition, and which we'll get into whenever we talk about Neil Hall's article. But there's actually a blog from Hague that discusses the difference. It's titled Issues with Functional versus Cosmetic Damage. So here's the article. You can access it. And this actually tells you their blueprint as to how they write the reports and the definitions that they apply. Now, the definitions that these engineers and the insurance companies now apply, it typically goes like this. It says functional damage used by Hague is a reduction in the water shedding capability or expected service life of the roofing material. Okay, so what they're saying is that if hail damages a metal roofing system or a tile roofing system or a shingle roofing system, but it does not affect or reduce its ability to shed water, okay, or reduce its service life, it's not damage. It doesn't qualify as damage as Hague Engineering applies.
So even if you see a dent, they say it doesn't matter.
Right.
It's got to fit that definition.
So you got a dent.
So people wonder how come we're so busy fighting all these hail damage claims and lawsuits up in Colorado. Well, geez, you know what happened up in Tennessee and Alabama and Mississippi, just a couple days ago. So we know we'll be fighting them there too.
And Hague actually goes so far, and they actually define in their paper what is cosmetic damage, okay? And they will document these cosmetic damages within photographs of the reports, but they still don't call that cosmetic damage. They will call that an impairment, a cosmetic impairment. They go so far, and they will not.
They won't use the word
damage. They will not do it.
Because why?
Because I don't know. It's a good question for them.
Dollar signs, baby. You know that, and I know that.
So, and here's how Hague Engineering. This is what I call the adjuster engineering disconnect. Hague Engineering gets to hide behind a very important fact that they state in their reports,
right,
and their position when they testify under oath. They say it is not the role of the engineer or roof consultant to interpret an insurance policy or making coverage decisions.
But they sure avoid a lot of. It's amazing to me how they say that, and so many of the insurance defense engineers seem to be some of the best scriveners in the world. Just about maybe they have lawyers working on their teams or something like that, or the lawyers are visiting with them beforehand, so they know not to use the word damage. They use the word impairment, and they know to go ahead and track the language in the insurance policy exclusion. So we've talked about this before, and don't get me wrong, there's a lot of really good engineers out there on the insurance company side. And frankly, you need people to go out there to say no your engineer doesn't know what he's talking about and things like that. So there's a real role for these engineers on the other side. But one of the things that we're always very, very careful and I guess maybe skeptical about is the wording that's used in some of the language of these engineers. It's obviously it's coached, it's placed there on purpose, and
well, it's disseminated. So this article talks about, and everybody out here knows that they should know, Hague Engineering has 2 different courses where they instruct how to do roof inspections. And it's their HCIC course, which is the Hague Engineering certification course for commercial roofing systems, and then the HCIR course for residential courses. And Scott Morrison actually developed this program, both for the residential and commercial. And in this program, they give them their definition of damage. It's not a coincidence that all the other engineering firms, all the insurance company adjusters have this language in their reports. It's because Hague Engineering has spent millions of dollars and a lot of time and money into these programs to try to show their credibility and also impact the market. And the insurance companies know that if they're applying a higher threshold to a metal roofing system than what they're required to pay for, and they can reasonably rely on this report, they argue there cannot be bad faith, number one. And number two, they didn't do anything wrong because they relied on this engineer. Now, the second reason why this is a problem is oftentimes more and more, as the insurance companies are still trying to save money, they don't send adjusters to the property that have any authority to adjust the claim. They either send an independent adjuster who's never seen the policy, doesn't know if there's a cosmetic damage limitation, or they send this engineer who will tell you, we don't want the policy, okay? And that's bad. It's bad because it leads to policyholders getting screwed, quite frankly. And so what the carriers have to do is they do have an obligation.
Larry's hanging around me a little bit too long, starting to use that real tough language out there.
So here's where the carriers fail in this process. They have the obligation to do what? To properly instruct its experts and to read their materials. And when there's a report that's provided that clearly documents damage, as the public adjusters know, as the contractors know, it's covered. And I know so many of you out there fight this issue because you're sitting there showing the adjuster at the desk the photographs, and you know the policy language, and they're just relying on an engineer that doesn't know the policy language or an IA who never went to the property. So really the issue that we deal with every single day, I do argue all the time that this business process leads to...
You shouldn't get so upset about it. Well, if they weren't doing this, I mean, we ought to send the insurance, we ought to send Hague a case of champagne. Rick does all this. Hey, just keep it up, boys. We're doing just fine, you know, except for the fact the truth is we feel really sorry for people that have to do this, but there is a reason why we've been so busy up there in Oklahoma City and Colorado and Texas and things like that is because of this.
So if you go to the next slide, what's even more infuriating to me based on this blog is that Hague actually provides legal case law analysis in their engineering blog as to how the courts have interpreted the language direct physical loss or damage. So here's Hague Engineering in a deposition telling me that they're not involved in the adjustment of claims. It's not their role to adjust a loss. And yet I've got a publication by their president of Hague Engineering that specifically analyzes case law that clearly shows that their approach to a functional damage standard has been rejected by every single court that's analyzed the issue. In fact, and they go into specifics, I'm going to keep it moving. If you go to the next slide, this is directly from the blog, and here's what it says. Several courts, so they didn't just do one analysis, they did multiple analysis, in various states have addressed the issue of what constitutes direct physical damage under an insurance policy. Remember, this is Hague Engineering. That's who's actually writing this. In almost all cases thus far, courts have ruled that cosmetic changes in roofing materials caused by wind or hail are, quote, damage under the insurance policy. They know. Hague Engineering knows. They published an article that they know what constitutes damage under an insurance policy. The carriers know what constitutes damage under the insurance policy. Then they continue.
But do they want to pay for that damage under the insurance policy?
No, they don't. Then it says that, however, does not mean, so they're holding on hope. They're hoping they can win this argument. That does not mean that the cosmetic changes are damage. That's not true. Whether those conditions are covered will depend on the policy wording, but then they don't want the insurance policy. And even if there is cosmetic damage exclusion or similar endorsement on the policy, coverage will vary depending on the specific policy wording and occasionally on the state in which the loss occurs if a court in that jurisdiction has made a ruling that sets a precedent. Of course, they don't cite any case law that supports their position that they should be applying any other damage than what constitutes damage under the insurance policy. And I have a whole lot of fun, Chip, with this blog and my depositions of Hague Engineering. Okay, it is a lot of fun because they will go with the script that, hey, we're not here to adjust claims. We don't know what's covered under insurance policy. Then I show them this blog, and I can show them that they do know what's covered under the insurance policy.
I bet you just won a whole bunch of friends with the Hague people talking about this today.
I didn't have any friends with them before.
So why don't we talk about claims review art before all that?
Yeah. So again, the industry acts like this is something that's not known. I mean, I have defense lawyers that have bought into these arguments. Some of them are newer to the first party world. Some of them are trying to get clients. And this next slide is an article from 2018. We will get into a paper from 2009. These are longstanding issues and longstanding legal principles that have been developed over time that for some reason still come up and are ignored during the claims process. But there's a claims review article that explains what cosmetic damage is, so that if you have a cosmetic damage limiting endorsement, what qualifies. And this is a good article to read because it talks about marring, pitting, and other superficial damage from hail. It gets into Hague's engineering of it not altering the functionality. And so if you go to the next slide, this gets into an example of what this law review, this article was reviewing.
I know, just almost from a lay standpoint, we were always, this whole thing of the cosmetic versus the functional is almost crazy. You think about vandalism claims, so you read the policy in total, you go through vandalism claims, many times under vandalism claims, no functional damage whatsoever. They just make the building looks bad. Somebody's put graffiti on it, somebody's just marred it. They just made it look, not good. You could take a statue and go ahead and paint it different colors, sort of back in your old fraternity days and stuff like that. You go paint the SAE line a different color. They all go crazy, but it still looks like a statue. Everybody knows, but it's changed its color and stuff like that. Those boys might not like it. Has there been damage? You just ask those SAEs. They'll throw you their shower if they catch you.
Right.
So they might even do something worse too. But again, it's and this is where the courts start talking about it. You start reading the policy in its entirety. And I know this is what Bill Wilson, a lot of it. Read the policy in the entirety. Does the policy cover cosmetic damage? It's supposed to. Now they make some limitations to it. Oh yeah, well what about, we're just going to limit to hail damage claims. No, really? Well, let's go through, and we're going to talk about some of this because the paradigm's now switching where the insurance companies are writing in cosmetic damage exclusions. And so
we're going to go to slide 26. And thank you we'll make sure we name the slide number as we go forward. Something I heard recently, Chip, well, not recently, but over the last 2 or 3 years, over and over again, is if you've got a property that is not where you can see the damage from ground level, like an HVAC, or if there's a roof that's metal and it's been damaged by hail, but it's not leaking, right? It's just cosmetic damage. They will argue that there is no loss because it hasn't affected the value of the property. You can't see the property. And of course, I lose my mind because when my client goes and sells that property, there's not going to be a single purchaser of that building that's not going to identify that as damaged and be concerned about when the roof needs to be
replaced. The same type of argument comes back up with you have a fire and somebody wants to go ahead and take this like aluminum or silver paint up in the attic area and say, we're not going to change this area that's been darkened and stuff like that. We're just going to paint it a different color. It'll encapsulate the odors and all this other kind of stuff and things like that. Well, at the time the sale takes place, the guy's going, what in the world happened up here? And they go, there was a fire up here. Really? Well, didn't you get replacement cost coverage? Yeah, well, it doesn't look like that brand new. Instead, you got something that's painted, and we know there's a fire that was up there. And by the way, some people complain about when it rains and it gets hot, that odor still seeps on through, and they can smell it through the rest of the house. And so we're going to deduct this from the amount. You either fix it or you give us another $5,000 off the price of the house. And the homeowner's thinking back, man, 12 years ago, I never should have gone ahead and gave into that insurance company adjuster on that particular item. So, these issues have been around for a long time that we've heard of. It's just that they're coming up in different ways. I'd suggest to the insurance industry, if you really want to take care of it, you could put different deductibles on for different amounts for different parts of the building. If you're really serious about doing this, at the same time, you also have to comply with federal law and sell a product, that truly is replacement cost coverage, as both Fannie Mae and Freddie Mac have. And for all agents watching this right now, you're on notice of what federal law is. All of us, even Megan over there, is on notice of what federal law is. And it says that if you're selling if you have a mortgage on your home, you have to comply with these federal regulations regarding the type of insurance you have It doesn't have any exceptions with respect to these, cosmetic damage exclusions and stuff like that. Everything that impacts the value of the collateral, Fannie Mae and Freddie Mac want to make certain that people can afford and will buy that coverage to make it a marketable security of that mortgage. So just pointing out some other issues out there why these products really shouldn't be sold out there, right? And but nevertheless, we're seeing them more and more often.
Yeah, and the more common example is storage units. Like I represent a lot of metal storage units, and depending if it's a standalone structure or it's a metal structure, or if you got a bunch of different types of structures on the property that are metal. We've also had cases where they use old containers.
Everybody
from
people have
trains.
Containers that are being used for their homes. It's amazing what people are doing with containers.
So, and the question becomes, as a policyholder, if you've got damage that you expect to be covered for it, and the carriers look at it, it's buyer's remorse. So, our business, we deal with buyer's remorse every single day. The carrier gets a claim on a piece of property, and they realize that, oh, wow, this property is not in good shape. We should have to pay for this damage. It didn't really have an effect on the value of the property. Sure, it's directly physically damaged, but where's your financial loss? So this isn't going to affect your business and a storage unit facility or the like. So I think really look out for those storage unit cases that are all metal, and the carriers look at it from a different standpoint. But here's an example of a policy revision that was incorporated into a Zurich policy. And if you read it closely, it says cosmetic loss or damage means damage that alters the physical appearance of the roof covering, but does not allow the imminent penetration of water or moisture through the roof covering, or does not result in the failure of the roof covering to perform its intended function to keep out water and moisture for the remainder of its anticipated useful service life. So to start off, they define cosmetic loss or damage. And what the intent of this provision is that if the roof doesn't leak, very similar to the Hague definition, the roof doesn't leak or does shorten the service span of the roofing system, there's no coverage. Then they define the roof covering, and it's everything. I mean, it includes what's protecting the underlayment, like a tile, and also the underlayment. Then here's the exclusion. It says cosmetic loss or damage to roof coverings caused by the perils of wind or hail. So this only applies to wind or hail. This policy does, however, cover wind or hail damage to roof coverings that allows, listen to this language, this is very restricted, the immediate penetration of water or moisture through the roof covering, or, and this is a little more broad, results in the failure of the roof covering to perform its intended function to keep out water and moisture for the remainder of its anticipated useful service life.
You see why he's not the Brad Pitt, he's the other guy, because you got to be nerdy as can be just to go and read that language the way Larry just read it, and everybody else is going, man, I need a cup of coffee. It's 2:40 in the afternoon. Right now, we're listening to Chip and Larry talk about how that language go one more time that you got so excited about.
The language is, it only covers if there's an immediate penetration of water or moisture through the roof covering, or results in the failure of the roof covering to perform its intended function to keep out water and moisture for the remainder of its anticipated
What
life.
cracks me up is judges write these opinions that say, everybody's supposed to read their policy. You have a duty to read your policy. I guarantee if those judges tried to read that language all the way through in their policy, they'd be just snoring away. Nobody reads their insurance policy all the way through before a loss happens. I mean, you think it's going to happen to the other guy. You rely upon your agent who has a license to tell you what it's there, and that's just the truth of the matter. But, since this is Chip Talks at 2:00, I think it's crazy that these judges actually write some of what they write about these duties of people having to fully read these policies. Don't get me wrong. It can come back and haunt you later on because the judges are going to read a contract and they want to enforce contracts because that's what judges go do. And so they're going to read the fine print, which can come back and haunt you. But the truth of the matter is, I think that for everybody who's watching, if you're a policyholder and you want to make certain that you have good quality insurance, you need to find a great quality insurance agent and find somebody who's very passionate about what they do. They got credentials. They're reading up. They're not going to tell you, oh, I can go ahead and find some cheaper insurance for you. And no, they don't do things like that. They're going to look you in the eye and say, you need to have this insurance because if this happens to you, and it might happen to you, that you need to be fully covered. And these are the risks that typically happen wherever it might be. But having a cosmetic damage exclusion or most circumstances is not good for most people, especially if you have value in your home, especially, but anything that has any type of, again, architectural significance whatsoever. there are parts of homes that have nothing to do other than with the aesthetic part of the home. It's what adds value to it. And you need to have you need to have policies that'll cover, for these types of damage, not be fighting your insurance company about it. So again, if you want to avoid this, and I talk about it in the book, Pay Up, go get yourself a great insurance agent. Maybe you won't follow your advice no matter what. You can't lead a horse to water and make them drink all the time, but a good agent's going to push you to go ahead and do it, at least explain, not worry that you're going to walk off, because they're so good. They have a lot of clients anyway.
So I like to get a little bit nerdy, and then I like to give you a practical point. So if you're a contractor or you're a public adjuster working with contractors, and you're out there working hard, and you're offering contingency contracts, you're promising the insured that you will do the work for what is paid for by the carrier. You need to know if there's exclusions in that policy, because if you're under contract with a policyholder and you find out there's a cosmetic damage limitation, and there's really two different types. There's this common type where it actually excludes coverage unless there's functional damage, and there's also ACV limitations to roofing surfaces. And if you've got a contract that says you're going to replace your roofing system for what the insurance company pays, and let's say everything goes perfectly, the insurance company does the right thing, you provide the scope, they pay it, and there's an ACV limitation in that policy, you've just guaranteed that consumer that you're going to replace their roof at RCV value at ACV cost.
So let's make sure, because not everybody's all up on this when you start. So what it's essentially saying is you've got an older roof, 10, 12, 15 years.
Typically 15
I've seen it up to 20, but I've seen them all in there. They're older than that. You haven't had a full roof replacement. You're not going to get the replacement cost coverage. All you're going to get paid ever is actual cash value. So that's usually a big problem, because most people are trying to keep that roof last as long as they possibly can. Of course, the insurance company then doesn't want to, from their viewpoint, pay for the entire cost of a roof that's older that gets damaged at that time. So making certain that you take a look at those insurance policies, in advance is extraordinarily, important. So,
all right, so let's get a little bit nerdy again. Go to the next slide. We're going to get our educational part out of the way, and then we'll have some question and answer. So
I'll let you take care of this case.
Thank you. So the question becomes, what?
That's because it's the nerdy part.
Thank you. So what constitutes direct physical loss or damage? So there's case law out there. And the carriers want to have more, like we talked about, a cosmetic damage approach, or more limited approach in direct physical loss or damage. And there's a case that the carriers often rely upon that is out of Michigan. It's called Universal Image Productions versus Chubb, and it's slide 27. And I'm not going to read the whole slide, but essentially it says, even though mold and bacteria permeated the floor because the entire premises did not need to be vacated, and the insured could not meet its burden to show it suffered any structural or any other, here's the key word, tangible damage to the property, there was no direct physical loss to the property. So the carriers argue that only tangible losses meet the threshold for direct physical loss. Now, this is being raised a lot, and this is what Ms. O'Malley discussed in her paper from Zell, is that, hey, if you got a bacteria or a virus that's airborne and it's not actually causing direct physical damage to your property, then there's no coverage. That you actually have to prove there's been direct physical damage or loss to the property. Now, there's a lot more case law that helps the policyholder on this issue. And the next slide, slide number 28, is a case out of Louisiana. And it's a Court of Appeal case called Witter versus Louisiana Citizens.
And our good buddy John Hotelling, who filed the first virus lawsuit out there in Louisiana, certainly to be relying upon this.
Yep. And it held that lead dust on property constitutes property damage. And it states that the carrier's own engineer in this case actually stated that the lead needed to be removed and it caused direct harm. And because of that, the engineers recommended that the children's toys be destroyed and other personal property should be destroyed if not properly cleanable. So something is like dust, where you may not be able to see it, it's particles. A lot like soot. Soot is actually, it's so small you can't see it. You actually have to get tests to confirm it's there or it's not there. That constitutes direct physical damage, even if it doesn't tangibly alter the property, right? So a lead dust on a toy needs to be thrown away or cleaned. Okay, it constitutes a direct physical loss or damage. All right. So the point of this case is the pre-existing state of the property has changed. That was what the court concluded. They actually said it was tangible and intangible because the toy was in a different state after the loss than it was before, and that constituted direct physical loss. And so, slide number 29, get there because it's a funny joke that Mr. Chip is going to try to hit on. Here we go.
So I had 3 black cats one time at this house, and we had all 3 of them, and I came home everybody can see this slide, right?
Right. Just in case they can't.
They can't. Everybody ought to be able to see that slide. So that's a cat. I wish I had a black cat that could do that, but my cats couldn't do that. Instead, come home and it's just smelling because one of them went, pee on one of the couches and stuff like that. So I had this bright idea. I would start trying to separate which cat, put a couple of cats outside at a time, and this and that. Either they're all doing it or they're, I have no idea. So I went down to the vet. You know what she told me? Because we were supposed to, like good owners of cats and stuff like that. And the vet, you know what she told me?
That you're a cat guy?
Nope, that she said all those cats ought to be outdoor cats from here on out because it costs a lot of money to replace those couches. And so if you remember this particular case right here, if cat odor, urine cat odor can satisfy the physical damage requirement, I guarantee you, absolutely guarantee you, that the coronavirus that's out there all over your property or in the air that you can prove is there, absolutely is going to be physical damage. And you were talking somewhat about dust, but remember in our discussions on our OSHA stuff, it reminds me, we're talking, one of the newest regulations that came out for OSHA has to do with silica dust. All these small little particulates of dust now, you got to have masks on for any worker that's around them because it's found of all the damage to everybody. It's an unsafe work environment to have and the stuff going all over the place. And that's just dust contaminating in the air. The physical presence of dust in the physical air, is dangerous. So, again, if it's against the law for doing like that, if it's dangerous and cat urine, the odor of it, I don't know if it's dangerous or not, but you sure as heck, at least nobody I know of can live around with the cat urine. Again, if you want to do this, Larry, you got to teach your cat to go something like that. I was not good enough to teach my cats that. Maybe I should have been more of a dog guy.
Yes, that'd be a good move. So under this case, Merlin versus Northern Security that Chip is talking
We talked about, let's go. We're running out of time.
The sense of smell and a distinct and demonstrable alteration of the property and constituted physical.
Y'all will never forget that cat case. If cat odor is bad, the coronavirus is bad too.
All right, so let's go ahead and just finish our discussion on the coronavirus because it's such a hot topic right now.
Okay.
And the question becomes, what constitutes a direct physical loss or damage? And I know that if you read our blog, we have been trying to be very direct, also providing both sides of the arguments. I think we've done a good job of that with our blog. What kind of was a game changer was these orders that came out, these civil authority orders, where it was clear, just like President Trump was clear last week, that he expects these insurance companies to provide coverage. That's not just a top-down approach. That is a bottom-up, top-down.
I said I wish at the Insurance Information Institute, I wish I was a fly on the wall to listen to all those propagandists over there trying to figure this one out, what they're about to say. I don't think they're going to call President Trump stupid. Do you?
No.
Because he'll probably say that Insurance Information Institute, I'll show them stupid. So anyway,
the first issue is, in our assessment of these cases, is there a virus exclusion? President Trump takes a very broad approach and says if there's no pandemic exclusion, there should be coverage. I don't think there's case law for or against that right now, but that's obviously the more broad approach. The more narrow approach, or we believe is going to be consistent with the case law, is if there's a virus exclusion, you're probably not going to have coverage because even if you have physical loss, you're not going to be able to get around your virus exclusion. However, if the courts rule differently on the pandemic exclusion, then obviously there could be coverage. But more importantly, we do feel there will be a lot of coverage under the civil authority portions of the policy. And under the civil authority, here's the key. It's one of the very unique coverages that does not require direct physical damage or loss to your insured property. I can't think of any other coverage right now where you can actually get coverage when somebody else's property is damaged. Okay?
Independent properties coverage and supplier coverage and supply chain coverage, theoretically, if you have the right coverage, you might be able to pick it up. And that's why we tell everybody, read the full policy and think about your own particular facts and circumstances of your own business. So I know a lot of people are thinking about, if I was a country club, a yacht club, because I'm a member of yacht clubs and country clubs, if I go to all these restaurants, I go to a lot of restaurants and I feel sorry for everybody there and they're out of business and stuff like that. Their types of coverage might be different than everybody else's, but every single policy, I hate to say it, you have to look at the dumb policy in order to figure these first things out. Do you have the virus exclusion or not? Your probabilities of winning are going to go up or down based on that. If you don't, what is your particular circumstance of your particular business? And by that I mean, are you a assembler of products and the products come from all over the world for you to be able to do things. That's a different circumstance and factual circumstance that maybe is a Starbucks or a coffee restaurant or a cafe restaurant. But I don't want to interrupt too much, but it's just so important for everybody to know their own facts and circumstances that can materially change the outcome of these cases.
All right, so I want to make sure we have about 12 minutes left. So let's get through these slides so we can answer some questions. And I want to get to the cybersecurity questions up there. And let's make sure, looks like Ed ordered your book and he's going to get it the other day. So, all right, so here's why these orders are important. The orders specifically say that the civil authority order is being issued because of property damage to property. And the reason why that's so significant is that if you're a Subway and you've got a McDonald's next to you, and McDonald's is being shut down, the argument's going to be from the policyholder standpoint of Subway is they're shutting down my Subway because there's damage to this property, and I've got a government order backing that position up.
Right.
As a policyholder, I believe that meets our burden. The carriers are going to argue that we need to show more, but that's going to be the debate there. But according to these orders, we believe there's a very strong potential that it's going to meet the standard of direct physical loss. I'm going to skip the slide 32 because we're going to keep rolling.
I'd read that paper though, because it does start to get into the risk of harm. And it's just when I was doing some of the background research, some of these academic articles that have been cited from some of the cybersecurity articles, are pretty important, especially when you start talking about, what's the risk that you want to avoid with respect to somebody who's got you, but it's a cyber type claim. If you don't give us this money, we're going to go and destroy your entire, data, and what does that mean? And so Ed, when you wrote in there that the cybersecurity cases are very important, we agree with you. We've looked at those. We know that they're going to be important. And again, the trend on the cybersecurity case is actually more liberal in finding, more coverage as we go through days.
So quickly, going back to the ABA article that was written in 2009, this particular article was very critical from the insurance industry standpoint as to why they leave physical loss or physical damage undefined. They speculate that physical damage is generally not defined, presumably because the insurance industry believes the term is sufficiently clear to define the parameters of its liability in most circumstances. That's kind of laughable because of all the cases that are dealing with this issue, including Merlin wrote our law firm did an amicus brief in Wisconsin in a case called Advanced Cable Company.
I wrote it, Larry.
Did you?
Yeah, I wrote that.
You did?
Probably me, Shane, Mary, and Ruck wrote it.
There you go.
Whose name do you see at the top there?
I see your name at the top.
Absolutely.
And this is a case from 2014. So here we are 6 years later, where Chip really goes into these issues, and we'll make sure you guys get this brief. But this includes industry standard articles. Like my favorite thing when I'm arguing with a defense lawyer who's being told something from their client is they think that we're just making this stuff up. They just think we're making it up. But in reality, when you look at insurance industry standards, I mean, what we have in our hand here is because,
So what Larry pulls out are the flashcards to the very first book on insurance principles. And if you order all the materials from, this is to get a CPCU or an associated claims handling. We go back, if judges will stop reading case law to figure out what these insurance policies mean, and instead go and look at the insurance industry's own, materials, you'll find that when attorneys argue for the insurance companies, there's nothing wrong. They're just making it. They will argue anything when they want to beat us.
Chip,
and they're good attorneys. I mean, there's nothing wrong. But go back and look, and Larry's going to pull off from the study cards just to show what some of these terms mean.
Just so you guys get an idea of what we deal with in court and why there's bad decisions, there's insurance company bad faith experts that will testify that third-party resources like AIC, Associated Claims Study Materials, your CPCU designation, the Model Claims Practices Act are not industry standards. That's what they'll testify to, that if there's not a case law on an issue in insurance, that there's no industry standard. It's laughable. It's literally laughable that we have to fight 702 motions against our experts because they're considering AIC textbook material, Markham on the claims environment, things that every single person in our industry should read and know and inside and out. And we're in front of a judge, and the judge is like listening to these ridiculous arguments. And if these insurance attorneys actually knew what they were talking about, they would understand why I'm looking at them like I'm confused. What the hell are you talking about? Of course, what what the Insurance Institute talks about as standards matters. And here's the flashcards. And I just picked it up. They were sitting on Chip's office. I guess Chip is just trying to continue to learn every day. They're just sitting on his office today. And here's the definition of direct loss.
I was just seeing if Larry could get them right or not.
And here's the best part. They cover indirect loss. Now, you never hear that talked about in these cases, do you? It covers both direct loss and indirect loss. And it defines direct loss as a reduction in the value of property that results directly and often immediately from damage to that property. It doesn't say anything about service life. It doesn't say anything about cosmetic damage. It says nothing. It says it affects the value, okay? And it's damaged, and it's been directly damaged. Here's something insurance companies never want to talk about anymore. Even though the Model Act calls it consequential damage, we also have what's called indirect loss that's covered under an insurance policy. So what is an indirect loss? Okay, so you don't just have direct physical damage to property or loss that's covered. You have consequential losses that are covered. The definition is a loss that arises as a result of damage to property other than the direct loss to the property. So the idea that you're not covered for when you got to remove siding because you got to replace a roof, or you've got consequential damages because your decking is no longer functional, is ridiculous. Sorry you got me on my little soap opera there. We got 5 minutes before we got to switch out.
We got to have some questions
2 minutes?
because it's supposed to be a discussion. Do we have any questions, Megan?
And here, I'll give it to you.
So how do we get?
Okay, so here's the
Ask me a
question.
Maybe let's see if somebody can stump us.
Yeah, sure. Explain why Larry is the. I'm sorry, no, that's not a question. Let's see here. Anybody have a? Okay, guys, go ahead and ask us a question here.
There's got to be a question somewhere. Is there? Where I could use this. This is dangerous for me to use a. Whoops.
Yeah. So one of the questions from Digitory Claims, it says, so civil authority would possibly provide coverage for people who lost business due to the closing down, even if they did not have the coronavirus actually present on the insured premises. The answer is yes.
Well, the answer is yes, of course. So let me tell you the reason why I keep saying this is going to be no cakewalk, guys. Okay, it says, and I can go down almost every single, not all of them, because we found some that don't have it today. And if you have a loss of use and occupancy coverage, that might even be better than civil authority coverage. Not everybody's going to go back and look for that. But anyway, typically it says it's got to be on an adjacent property, or now it says property not further than a mile. It used to say 10 miles when I was going back 20 years ago. Now it's down to a mile. And so then I know what the insurance company's going to say, so I can hear Shannon. Okay, Chip, no problem. Show me where that physical damage is, within a mile of your property. And that's like I've been actually going around asking some other people. I go, hey, do you know anybody knows how to test for physical damage? You know of a test that'll show the presence of the coronavirus? It's like crickets. I even wrote a thing about that where somebody was saying the only time they ever did a test is after they clean everything up. And they said it always came back to be zero. It was always negative. The coronavirus is ever there. And I said, well, have you ever run the test and it ever came back to be positive at all?
Right.
No, it's always come back negative. I said, how do you know your test works? Crickets. These are going to be the tough questions that the insurance company attorneys are going to ask. And I know a lot of people are out there, people are like this. No, they don't look this thing over. Words mean something. They're there, and you got to read the whole policy that says these things in there. I think it's easier if I was, for the medical, somebody's got it and they're sick and stuff like that, but it's sort of the same thing. Well, why can't you clean it up, Chip? Because you can sanitize it within, a day or so or something like that at the latest. And most of the time, the coronavirus might even die within that period of time, or whatever it might be. But again, you don't satisfy the 72-hour, provision within the business interruption. How are you going to get around that, Chip?
Well, so one of the questions,
and these are going to be the tough. That's why I keep saying, guys, these cases are not going to be a cakewalk to go win. And there's a lot of attorneys that are just looking at me like, what are you talking about, Chip? And they're looking because a lot of these people never done it before, but they know how to advertise to get cases.
And if we get cut off, thank you for joining us. Please get the information real quick.
Oh, you put the pay up thing up there.
Last
you know what? If you notice, go back. There's nobody walking around because on the very day that came up on slide 37, Megan, you got slide 37 up there. So on the day of the coronavirus, when they start having everybody to stay at home, this is like the last thing that's out there. Usually Times Square is packed, but it wasn't packed. Oh, so they were nice enough to send me, the photograph just recently, from that. So it's kind of cool up in Times Square with Forbes. I appreciate everything Forbes has done for me on this thing. They've been really great. They've really been great to work with and stuff. So, hey, appreciate it. And some of these stuff we talk about and pay up what people should do after you have what business owners should do, after loss, and what you should do to pick a great agent, what you should do to pick a public adjuster, and most important, what you should do to pick a great attorney to represent you, on these cases. Did you find any other good questions in there?
Yeah, so two more real quick. Number one, Michael Muma, regarding your matching question, please go back and watch our video from last week. We definitely crushed that issue. That we provide a lot of standards. Excuse me? It's in YouTube.
It's on YouTube.
Go to YouTube.
Merlin Law Group,
Yeah.
YouTube, right?
And if you do that, you'll be able to get all the materials. And if you email us for the PowerPoint, we'll get it for you.
And you can go to Chip Merlin blog, and in the research section, you put the word matching in there. I forget how many. I mean, it's unbelievable how many times we've written about matching. It's hard to believe somebody could have something that we don't know about. So what's another question?
Okay, so another question is, what if the virus, you kind of hit on it, what if the virus is dead? Do they still get that coverage? Or if you can't prove that, I think, again, that's where the distinction of damage to property of others and the significance of the order. The answer is we don't know what that decision is going to be, but the argument on both sides is the following. One, the policyholder will argue there's coverage because the civil authority order took effect and they've been shut down for that period of time because of damage to property to others based on that order. The carrier will argue that we have not met our burden of proof unless we can show there's actually the virus on the property of others and or our own property. Okay, so the answer is that's undecided. Lastly, someone asked me to repeat
I guarantee you, if you're within a mile of one of those hospitals up in Manhattan, and there's a number of hospitals, you're going to be within a mile where there's physical damage. So I know everybody's out there, every New York attorney in Manhattan right now going, oh, Chip, geez, that's a great idea. And there's a whole bunch of restaurants that are around a mile of some hospital or clinic where I guarantee you there have been people that have been tested positive for the coronavirus. I bet you that restaurant down there in New Orleans is within a mile of some of those, hospitals, so they're within that frame of other physical damage where people might be. So, there's some claims out there to be pushed on this. You also have to read how much money we going after. And I've read some stuff Bill Wilson mentioned and stuff like that. Just remember, some of these policies only limit the civil authority to 2, 3, or 4 weeks. That's usually about the maximum amount. I've seen some older ones talking about 60 days. So,
if you go on my Facebook Live and YouTube, you'll be able to, I did a whole presentation on coronavirus. I broke down all of the different issues.
Was it as exciting and fun as this?
Oh, no.
No way.
No. So guys, thank you so much for everything. Oh, we actually have a coronavirus page that will break down these issues. Or if you have any questions, like we had a dentist here that had a question, would love for you to reach out to our page and contact us, and we'll be able to address your questions. We are looking at policies. We are taking these claims. We're doing it with a honest approach. We're giving the facts to the clients, just like you guys should be doing, that there's going to be a lot of issues up in the air. We do feel that we're going to be able to help a lot of people depending on the policy language. So thank you so much. Chip, do you have anything to conclude?
Yeah, on Friday, I'm going to be with Amy Bach of United Policyholders and Holly Soffer, General Counsel for the American Association of Public Insurance Adjusters. We're going to be talking about insurance gaps and how to avoid those. We're going to be talking about the coronavirus again, so we'll have updates 3 days from now. And I forget the last thing that we were. And we're going to be talking about. I forget what else we're talking about on, but that'll be on Friday at what time, Megan?
Let me get back to you.
It'll be sometime this Friday that with Amy and Holly, and I'll have something come out on the blog just shortly. But hey, this has been fun. Thanks for your questions, and never hesitate to reach out if you have other questions. Please read those materials. We went through and selected them on purpose, and I think they've been quite helpful to you, not just with respect to the virus, but also what you can do on other types of claims where the issue of physical damage comes up. Thank you very much.